thank you everyone for being here in person and virtually. It's a great pleasure to host you for this presentation this morning. Um, it's really that time of the year, and I'll introduce my panelists in a second. It's really that time of the year where we look back as to what happened in 2022, and we look forward to what's happening or what we predict will be happening in 2023. So cybersecurity is no exception. So that's the purpose of our presentation this morning, cybersecurity top trends, what to look for in 2023. So with me today, I have two panelists. I have Danielle on my right. Will be discussing and she's our specialist in privacy at the firm. She'll be discussing some of the trends on the privacy enforcement actions around that. And on my left, I have Marjorie, who had the pleasure working with on a couple of cyber breaches. And she's specialized in litigation, but also dealing with cyber responses in cybersecurity, as well as Danielle also. Um, so today we'll try to come up with an overview of what we've seen in terms of statistical trends in the cybersecurity world, legal trends, as well as practice point through our file in connection with cybersecurity. Um, I know the introduction mentioned I will be fully in English. I think we'll try to do a bilingual presentation in the spirits of Montreal. So part of it will be in English and part of it will be in French. But feel free to ask question in a language that you prefer, either French or English. It's all good from our perspective. So in terms of logistic points, so in terms of questions, I'm being told that for people that are online, there's dessous le lecteur vidéo. Vous voyez sur votre écran, il y a un onglet qui s'appelle Ask any question or poser une question. Vous pouvez utiliser cet endroit-là pour poser votre question durant la présentation. Veuillez prendre note, par contre, qu'il y a un petit délai de 10 secondes entre ce que vous voyez et ce que vous allez taper comme question. Donc, il pourra y avoir un petit délai dans la réponse. So we'll try to respond to the questions as we go. I think the purpose of the presentation is to be interactive with people and to have a dialogue around cybersecurity. I know everyone has their own experience related to cybersecurity. So we welcome questions during the presentation. And without further ado, I think we will start with the first slide. So before we jump on a trending subject of cybersecurity, let's clearly define what we mean by cyber risk. So we can divide cyber risk as a risk to information assets that have consequence affecting three main components. So confidentiality, integrity, and availability. So when it comes to confidentiality is what would be the impact on your business if important information is disclosed publicly? Integrity is, are your IT systems secure? Do you have an absolute confidence into your IT system that it will work to protect your organization? And the third one is availability. So, can your business operate without access to internet for or email for a few hours, a few weeks, or a few months? So, can your business operate without business access to information that we can consider crown jewel to your business objective? So, back in the old days, protecting organization in terms of cyber incident was really about protecting data, protecting personal information, and I think we were discussing a lot on the privacy side, and I think that was the main focus. But nowadays, and we'll see when we discuss about some of the trends, it goes much further than that. And I think we're more about dealing with how do you protect your organization as a whole? Because we all know all the system within each of the organization are interconnected, and therefore, if we only think about a supply chain, a company that it's fully depending on its supply chain without internet or without connection, there's nothing working. So I think we're dealing more with the second integrity and availability of access to your system, and not only the first part, which was the general or original concern about cybersecurity. So, looking at some of the recent trends in terms of cyber attacks, so what we can see, and it's just a subset of what happened in 2022. As you can see from this slide, there's a lot of company that were subject of a cyber attack, and it's just a subset in the sense that some of the company will touch upon that at the end of the presentation when we discuss about disclosure obligation, but some of these company are not in that list because they either did not disclose publicly their cyber breach because it was not big enough, or depending on timing, there are a couple of reasons why they could not disclose. But also, there's a lot more company that we could have put in this slide. So all this to say, and we'll touch upon that on the next slide. But what we see is that in 2022, there was an increase of 38% of cyber breaches in Canada. And if you compare with the North America as a whole, including obviously the United States, we're looking at 52% increase just in the last year. So in terms of trends, what we see is, as you can see from the pie chart on the right of the screen, um, what comes out of this slide is that no, everyone's at risk. So all industries are at risk of being a victim of a cyber breach. So we heard a lot about healthcare system, education, professional firms, even retail manufacturing. But when you look at the numbers, really, it's just across the board. So I think it's a variety of different industry being victims. So in terms of type of incidents, if you look at the pie chart on the left, what we see is a growing number of ransomware attacks. And I think we've seen that as part of our files as well. This is a recurrent trend, and I think we will touch also upon that when we talk about insurance in a second. But so what we see is, so long as ransomware remain profitable, so therefore people are paying, there will be more and more. So I think that's what we see, because when we look at the numbers in 2022, sorry, half of the organization paid a ransom. And the ransom range from 250K to a million. And what we see in part of our file is a negotiable amount of money, right? Because although the criminals are asking for a high price, there's always a way to negotiate that price down. And there's a lot of discussion around that. But basically, at the end, what we look is 250 to a million. So the amount of payment under ransomware have been increased in the last year also. What does that tell us? That tells us that either some organization define or determine that it was better for them to pay to either get access to their system quickly enough, whether they couldn't get access to all their data or recuperate some of their data. So there could be a lot of reason why companies are paying, but it's definitely something on the rise as well. So what we're also seeing what we've seen in the last year as well is a more sophistication in the form of cyber attack. So what I mean by that is that obviously ransomware is usually a criminal trying to encrypt some of your data and then blocking the entry to your system. So you realize that basically you have no choice but to pay. But what they're doing, and what we noticed in a couple of files in the last year, is that they're not only doing that, but they're also doing another intervention and getting access to the clients or the suppliers. So basically, doing their role as criminal and trying to get access to as many people as possible to pressure them to pay the ransom. So basically, they're just trying to increase the pool of company willing or being in a position that they have no choice but to pay. Um, what we also see in terms of trends is critical infrastructure providers, especially in the energy and utility sector. that are particularly vulnerable to supply chain compromise. So what we've seen is that they compromise some of their vendor or someone in a change of information. So vendor supply or anyone that has a connection with an issuer or a company system, they compromise that person first, and then the company gets compromised next. So it's a chain of event. So I think it's always to say that one thing we recommend to clients is obviously look at your ecosystem, but also look at who has access to your own ecosystem because it may impact what happened next. And maybe the last trend is, without any surprise, is the state-sponsored cyber breaches with the geopolitical kind of environment we've been dealing with in the last year. There's been a lot of state-sponsored cyber attacks, so Canada is no exception to that. When it goes to increase cost of insurance, so what we've seen is similar to what we've seen for DNO insurance as a whole. We've seen an increase in a premium, um, and so cybersecurity is no exception to that. How do we explain that increase? I think a couple of factors. The average cost of a data breach continue to increase. I think with the inflation and the cost of everything being higher, I think cyber breaches and responses, suffer the same experience. The increase of cyber attack lead to an increase of insurance payout. So the insurance company pay more, and if they pay more, they need to charge it back to their clients. So they're increasing premium to kind of compensate it for that. uh, Also, an increased cost of lawsuit, ransomware payout. As I said, more payout, more increased amount of payout for ransomware. That has an impact generally on the premium as well. What we've seen also is certain coverage being dropped. So nation stated attacks for certain instances have been removed from some of the protection given what happened in the last year. We also see kind of ransomware protection or payout being removed either at the demand of the clients because it's too expensive or at the insurance company demands. Another trends that we've seen for insurance, cybersecurity insurance, is it's harder to qualify. So it's not because you want a cybersecurity policy that you're going to get it. They're being Companies are being scrutinized even more than before. So what we usually recommend is making sure that you do your audit before you actually apply for a cybersecurity policy or you even renew it, just to make sure there's no vulnerability that will be discovered by the insurance company, and then either increasing your coverage or removing or reducing the amount or even completely removing your ability to have coverage under a cyber security policy. So now moving to the new reporting obligation in Quebec and turning to Danielle.
Thank you. Yeah, I'll take the clicker. So our third trend is our new reporting obligations in Quebec. Sorry, this isn't working. And what I want to do is I want to preface this by saying that the landscape is chaos in Canada and North America and around the world, because there are no two things that are the same here. Now, just coming back to Canada, what makes it complicated in Canada is that our cyber reporting obligations and our privacy laws depend on sector, and it depends on province. So what I mean by that is the public sector and the private sector have different laws with respect to protection of data and with privacy incident reporting, or privacy incident reporting. The federal government has two laws, so Access to Information and the Privacy Act. These will be the laws that govern how you handle data in the public sector federally. Provincially, you have the same structure, but combined usually in one law, which is an Access to Information and Protection of Personal Information Act. Now, pardon me. So provincially, the other thing is that we have Health Information Privacy Act or Health Information Protection Act. And again, here, it's very complicated because practically no two laws are the same. For example, Some provinces require disclosure regardless of whether there's a risk of damage. Some provinces don't. So you have to really know what sector you're in and what kind of information you're dealing with. That's the public sector. The private sector in Canada has 4 laws that you need to know about. The first is the federal law, which is PIPEDA, or the Personal Information Protection and Electronic Document Act. And that act regulates the protection of personal information in every province except for Alberta, British Columbia, and Quebec. Now, federally chartered organizations in those provinces are regulated by the federal act, but barring that, everything is regulated by the provincial legislation. To make matters even more complicated, British Columbia does not have breach reporting in the private sector yet, whereas Quebec has just introduced it. Alberta had it since 2010, and the federal government introduced it in 2018. So that's the background. Nothing's the same. You really have to know what sector you're in, what province you're in, what law you're dealing with. That said, we move on to concretely what's going on. When I look at privacy breaches, what I like to ask are basically the who, what, when, where, how question, and that pretty much covers it. So what I'm talking about is what are we disclosing? Well, we're disclosing a privacy incident. Now, how is a privacy incident or a confidentiality incident or a security incident defined? Thank God in Canada, it's usually defined the same way. So what it is a loss or an unauthorized access, use, disclosure, in Quebec communication of personal information. So that's pretty much the same. That we have to disclose. Who do we disclose it to? Well, we have to disclose. Wait, sorry, I'm backing up. We disclose a confidential incident when there's a real risk of significant harm federally or provincially, the risk of serious injury. It's not clear that the test is going to be the same in Quebec and the federal level, but we think it probably will be. It's too early to tell. This is an obligation that is new as of 3 months ago, as of September. Now, when we look at the risk of serious injury, we want to look at the sensitivity of the personal information, the anticipated consequences of its use, and the likelihood that such information will be used for injurious purposes. I'll give you an example. If an employee loses a USB key, or if the employee's USB key is dropped down a sewer, that's a loss. It's human error. The likelihood of recuperating that USB key and that information being used to an injurious purpose are pretty low. So that's the kind of breach you probably don't need to report. However, if, as Vanessa was talking about, you suffer a cyber attack, already you've got illegal activity. They're probably in after the crown jewels, and many documents have probably been compromised. That's the kind of thing that you probably want to disclose. And what we see right now, and I think Vanessa and Marjorie can testify to this as well, is that there's frequently a knee-jerk reaction. Oh my God, I've had a cyber attack. I've had a data loss or security incident. I need to disclose it. That isn't necessarily the case, and that's where we can help you navigate what needs to be disclosed, what doesn't need to be disclosed, because there's no point disclosing information that isn't going to cause a real risk of significant harm. So that is the what. Now, who do I disclose it to? I have to disclose it if I see that there's a real risk of significant harm or a risk of serious injury. I need to disclose it to, obviously, the privacy regulators. And each province has their own privacy regulator, and the federal government has their privacy commission as well. I also have to disclose it to the individual whose information was compromised, and I have to disclose it to any organization that can help mitigate the damages. So that could be the RCMP, it could be reporting institutions, it could be the bank, it could be credit cards. So if I, as an organization, have suffered a security incident that will cause a risk of harm, and I need now to notify, it doesn't just stop at the commissioners and the individuals. Other people may need to be notified, so you have to look into that. And again, they may not be, but you have to analyze this on a case-by-case basis. When do I notify? I notify as soon as reasonably possible. So that doesn't mean 72 hours like it does in Europe. Europe is much more demanding. And in Europe, you have to notify if you have a breach that you've discovered within 72 hours. In the US, it is different. Again, some states impose a 45-day limit on that. So really, you have to figure out which jurisdiction you're in. Um, where, as in which jurisdictions require notice? Again, I come back to this. Any jurisdiction covered by the federal legislation. Yeah, sorry, go ahead. Yep.
Very large GDPR, I think, laws that apply extraterritorially.
Yep.
But you also have your Quebec privacy laws. So which one will prevail, I guess?
Well, you have to disclose everywhere where an individual's information has been so if an individual resides in Quebec and their information has been compromised, you need to disclose that to the Quebec regulator. If you've had an incident and it's a European national's information, the applicable European Privacy Commission will have to be notified.
Okay, so it's based on the individual.
It really is. The scope will be determined by the residence of the individual.
But if I may, there's always kind of a discussion around if I disclose in Europe, will that be known in Canada? Would there be any impact? So there's a legal requirement, there's marketing, there's commercial consideration when we deal with that because people will want to know. So what does that mean if I tell this or 100 or 200 people in that location? Should I tell the other person at the same time? And the big problem with the notification provision in Europe is that it's very quick.
Yeah.
Because where we deal with that situation, just by the time you hire your IT consultant and you sign your engagement letter, it takes a few days just to do that. If you don't have one on retainer, to find one, to call your lawyer, to find your IT department, to negotiate your engagement letter, to sign your contract, you're looking at a few days already. So there's always a challenge of making through the delays and rightfully you have to deal with a bunch of different delays, and we'll talk about public companies at the end of the presentation. You also need to deal with your obligation as a public company if you are one. So I think there's a struggle as to compliance with everything at the same time, but all the rules being different.
Well, in Europe also, though, they've thought this out a little better. So the European commissions will work together. You have a lead. So the commission where usually the individuals and the most individuals are situated will take the lead and will cooperate. Canada also, I mean, in fairness, there's a tremendous amount of cooperation among the various privacy commissions. So,
And is it fair to say that the European rules are more strict than Quebec ones?
yeah, they are and they aren't just because of the way it's structured. There's without denigrating Quebec, there's a logic to the European. There's a structural logic to the European legislation. Quebec's legislation, because of the way it's evolved, it has become extremely severe and much more severe than anything else in Canada. But it, just because of what it applies to. Mhm.
Deal with the other commissioners, or do we have an obligation to each and every one of them?
You have an obligation to each and every one of them, but they will work together. It's not complicated in that you have each of the commissioners on their sites have forms, breach reporting forms, and you fill those in. You submit them digitally. They're not monstrous to fill in, but they will ask who else you've notified. And so you just tell them that you've notified the other privacy commissioners and the decisions, for example, if you see the Desjardins decision, I think that was decided by 4 commissioners, the federal, Quebec, Alberta, and British Columbia. So they very frequently work together. The other thing I would say, just to, in support of Vanessa's point, is what I usually do if we don't know is all of the details regarding a breach is that I do a preliminary. You're encouraged in Canada to do and provinces to do a preliminary notification, and then you follow that up when you know the details. The details can change substantially, and I've done that where they have, and that's fine. It's appreciated. It's just to show that you're on the case. You're not trying to shove it under the carpet and ignore it. So, and again, I find my experience with the commissions has been very positive. They're extremely helpful. They're there to help. They're not there to bother you.
And we generally take an approach to the points of risk of serious injury versus the federal test. So far, it hasn't been tested really, but when we do have a cyber breach, we take an approach that we apply the test generally to the same way in each of the province, and
Yeah.
we kind of report on that basis until we hear otherwise from the from the Quebec Privacy Commissioner, that they apply the test, because as you saw, the difference is the real component of it. So it's not clear what that means in practice. Is that the fact that there's no real as part of the definition? Does it really change the threshold or not? So we're kind of thinking, and that's what we deal most of the time with, kind of cross sometimes cross border, but also kind of big cyber bridge throughout Canada. So we take an approach that we notify everyone at the same time.
Absolutely. How? How do I notify? Well, I'm held to notify individuals directly. Now, that can be through email. It can also be through regular mail. If I can't notify an individual directly, either because it's too expensive for the organization, because I don't have their information anymore, or because it risks causing more anxiety to the individual or a more substantial damage, then I can notify them publicly, usually by a notice on my internet site, which I think most companies would like to avoid. It's negative publicity. However, it's not unheard of. In Canada, we still view it that way. In Europe, sometimes there are areas on big companies' websites where you get the latest update on the latest breach, because it's just, I mean, that's unfortunately part of life. I don't I mean, I think it would be an access to information issue, but it's not published. It's not published, and the Alberta Commission, in fact, will only publish decisions that are negative. So if an organization didn't notify properly and it went to an appeal, that would be published. But anybody who does comply doesn't get published, which is tricky for us because it's hard to gauge trends. Absolutely, and that's what we
Yeah,
recommend.
although our role is mostly to guide you through it, because what they'll do, the first two parts. So the IT consultant that you typically use for your run of the miles kind of cybersecurity assessment usually won't be the same one that you hire. It could be if you have them on a retainer, but sometimes you hire someone specialized in investigation as part of a cyber breach. So it's either you do have them on a retainer or you have a separate one. What they do is they will kind of provide kind of the raw data that they find as part of their internal investigation. So they will give them keyword of things we think will be sensitive information that may get to that test, and they provide them in a raw kind of format, and then we will guide you with someone internally to kind of go through that information in order to come up with a list of individual, because usually it's not only one word, right? It's a combination of a couple of personal information. I'll give you an example: an address and a name. Sometimes we take the approach, maybe you won't do much with that, but you have an address and a name, medical condition, then you can identify someone. So we need to come up with a lot of combination, and the IT consultant won't do that for you. They will find and dig for the information, but the legal firm will help you and guide you through that process and guide the IT consultant to kind of organize that raw information.
But they will do the forensics, and that's important. We're not forensic experts. That's what I mean. Yeah,
Yeah.
they will absolutely do the forensics, and it's completely recommended that you do an outside forensic investigation. Are there other questions? No. Okay, I will go to the next slide so everybody has a chance to talk. Another distinction in Canada is our register. So, regardless of whether you disclose your incident or not, or notify of your incident or not, we have an obligation in Canada, federally and provincially, to keep a register of all incidents that the company has suffered. And the rationale behind this is to enable a commissioner to understand why you decided or you didn't or you decided not to notify people. So what they want is they want to know the rationale you went through to decide whether there was a risk of significant harm or a real risk of significant harm. Federally, that register is a 2-year registry, so it has to be kept for 24 months. Quebec is requiring 5 years. So just be cognizant of that. There are also in Quebec a new penalty regime. So we've got administrative monetary penalties that are very comparable to what they're now going to be charging in Europe or used to penalize people in Europe. There are penal offenses. People can be held criminally responsible, and there's a private right of action, which obviously equates to class action. So those are the new rights that are created under this this regime. The one other thing I wanted to speak about when I'm talking about how to respond to a breach is we have an obligation to mitigate breaches, right? So if there is a breach and we think that there's damage, in the notice that we send to individuals, we have to do our best to try and mitigate any potential damage being identity theft, loss of revenue, loss of credit opportunity. So there's also an obligation to provide credit monitoring or to compensate for any other potential damages that could happen. This, again, is something that that is not consistent province to province. Market for this in the rest of Canada is 2 years of credit monitoring. Because of the Desjardins decision, it's now 5 years in Quebec. So there's also an incongruity when you come to Quebec with respect to what you need to offer a victim of a cyber attack. So just be cognizant of that. And I will finish on this. The Commission d'accès à l'information is supposed to develop and make public a general framework for the application of the administrative monetary penalties, i.e., who will get fined what, when. Fines are not the same across the board. They will depend on the size of the organization, the ability to pay, the seriousness of the incident, whether it's a repeat opinion. And if we look at what's gone on in Europe, it's not an exaggeration to say that really the large fines that the GDPR has levied have really been against the GAFA, the Google, Amazon, Facebook, what are the other ones? Microsoft, Apple of this world. And this has been boiling for 20 or 30 years. They have been looking for an excuse to go after some of these organizations for some of their practices that they view to be egregious. So those penalties, the very high penalties, have been used to go after these organizations. Other organizations have been fined in Europe, but really at a much lower threshold. So I think that we can probably rest assured that, unless you're really behaving in a way that's offensive and doing something that's incredibly damaging to individuals or haven't reported something, at least in the short term, the Commission will probably veer to the lower side of the penalties than to the higher side. Are there questions? Otherwise, I'll hand this over. So that was just my conclusion. Even though things are similar, just be aware that Quebec has higher penalties and a lower threshold when it comes to deciding what a real risk of significant harm will be.
Est-ce que c'est mon micro? Oui, ça fonctionne.
Ça.
Donc, un des trends dont il faut absolument parler lorsqu'on parle d'incidents de cybersécurité, ce sont les risques de litige. Comme vous le savez et vous l'avez probablement vu dans les journaux dans les dernières années, aussitôt qu'un incident de sécurité, un breach en fait, est rendu public, normalement, on attend quelques jours et on va voir des articles de journaux apparaître comme de quoi qu'il y a des réclamations qui ont été déposées directement contre la compagnie. Donc ça, c'est un des risques importants en matière d'incidents de cybersécurité. En termes de réclamation, ce dont on parle le plus souvent, et je vous dirais que c'est l'écrasante majorité des cas, on parle d'action collective. On commence à voir autre chose aux États-Unis, puis Vanessa aura l'occasion de revenir là-dessus, notamment des actions dérivées, des actions contre les administrateurs. Mais pour le moment, au Canada, c'est vraiment des actions collectives que nous allons voir le plus. Tout ce que Daniel vient d'expliquer en matière de notification devient très, très important quand on s'expose à un risque de litige parce que ultimement, dans le cadre d'une action collective, les tribunaux vont évaluer chacun des aspects de la notification, des comportements de la compagnie en matière de cybersécurité, de la façon dont les données étaient protégées pour évaluer si oui ou non la compagnie a commis une faute. Ça fait à peu près 10 ans qu'on voit peut-être un petit peu plus, 10-12 ans, qu'on voit des actions collectives en lien avec des incidents de cybersécurité. Il y a de ça 10-12 ans, je vous aurais fait la même présentation et je vous aurais dit que les gens croyaient à tort que dès qu'il y avait un incident de cybersécurité, la compagnie était responsable. Donc, elle avait fait défaut de protéger les données personnelles. La compagnie est responsable et elle doit dédommager les victimes. On est chanceux ou pas. Au Québec, on est une juridiction, comme vous le savez probablement, où on a beaucoup d'actions collectives, notamment parce que c'est plus permissif au niveau de l'autorisation, ce qui permet à l'action collective de procéder sur le fond. Donc, il y a beaucoup d'actions collectives à travers le Canada qui sont déposées en premier lieu au Québec. Et les 10 dernières années en matière d'action collective nous ont montré que dès qu'une compagnie subit une attaque et est poursuivie en lien avec cette attaque-là, elle ne sera pas nécessairement tenue responsable. Donc, un n'égale pas l'autre. Les tribunaux vont aller faire une analyse beaucoup plus détaillée des comportements de la compagnie. Au niveau de la faute, à savoir si la compagnie est fautive envers les gens pour qui les données ont été compromises, les tribunaux vont regarder notamment les mesures de sécurité en place avant l'incident. Donc, est-ce que la compagnie avait des mesures de sécurité qui étaient suffisantes pour protéger les données personnelles? Est-ce que les employés avaient un training qui était suffisant en matière de protection des données? Est-ce que la compagnie avait des pare-feux en place? Tout ça va être regardé par les tribunaux à savoir si l'incident aurait pu être prévenu ou non. Les tribunaux sont très clairs à l'effet que les pirates informatiques sont maintenant sophistiqués et il n'est pas vrai que l'ensemble des attaques auraient pu être prévenues. Donc, on demande aux compagnies d'avoir un très haut niveau de sécurité des données, mais les compagnies ne sont pas à l'épreuve d'une cyberattaque puisque les pirates sont très sophistiqués maintenant et peuvent réussir à déjouer les systèmes en place des compagnies quand même. Un autre aspect qui va être regardé, ça va être les politiques internes de la compagnie en matière de gestion des données. Donc, qui a accès à ces données-là? On a vu des cas, par exemple, dans les dernières années où tous les données personnelles étaient storées dans une base de données et l'ensemble des employés de la compagnie avaient accès à cette base de données-là, alors que le tiers d'entre eux aurait pu faire leur travail sans avoir accès à ces données personnelles-là. Donc, ça va être un autre élément qui va être regardé par les tribunaux pour déterminer si oui ou non une entreprise a commis une faute ou pas et doit être tenue responsable envers les victimes.
Juste un petit point là-dessus. Ça a l'air surprenant là, comme fait, mais on en a vu dans des cyberincidents, des spreadsheets d'informations personnelles avec tous les numéros d'assurance sociale dans un spreadsheet qui est même pas codifié de password ou autrement, là, et qui circule dans l'organisation aux gens de finance, RH et autres. Donc, c'est pas totalement loufoque là, comme série de faits. On en voit encore dans les organisations.
Oui, tout à fait. On en voit, en fait, dans notre travail constamment. Puis c'est que les gens faut penser aussi à l'intérieur d'une compagnie, les gens font leur travail puis n'ont pas ces notions-là en tête à chaque fois où ils ouvrent un document ou souvent, par exemple, qu'est-ce qu'on a dans les data breach? Les gens, ils vont avoir une boîte courriel qui va être compromise puis ils vont nous dire non, 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 il n'y a pas d'informations personnelles là-dedans, inquiète-toi pas. OK, on va regarder puis on verra après. Puis là, une fois qu'on regarde, finalement, telle date, on avait pris les passeports des employés parce qu'on s'en allait à telle rencontre, à tel endroit, puis on avait besoin des passeports. Bon, ça, c'est de l'information personnelle. Les gens ne savent même pas qu'ils possèdent cette information-là. Puis c'est en faisant ces recherches-là qu'on est capable de voir justement qu'on a plus d'informations personnelles qu'on pense dans nos boîtes courriels puis dans nos bases de données.
Formé au protocole de sécurité n'a pas nécessairement une faute. La première ligne ici. Alors, comment on concilie tout ça?
Oui, ce que je voulais dire, en fait, breach of security safeguard, c'est dès qu'il y a un incident de cybersécurité, dès qu'il y a un cyber breach, ça ne veut pas dire que l'entreprise est fautive. C'est que des fois, les pirates sont tellement sophistiqués qu'ils vont arriver à déjouer les plus hauts niveaux de sécurité d'une compagnie.
Ah, OK. Mais quand même, l'entreprise a une obligation de mettre en place des protocoles de safeguard, comme
Oui,
on dit. Oui, mais
ouais.
c'est ça.
Mais des safeguards qui sont raisonnables. C'est-à-dire que dépendamment de l'industrie dans
OK.
laquelle vous œuvrez,
Oui, oui.
c'est comme ça qu'on va juger. Donc, si c'est une industrie qui ne traite pas de données hyper sensibles,
Mhm.
donc il y a un niveau qui est moindre
D'accord.
qu'une entreprise qui traite des données
OK.
de santé, par exemple.
Merci.
Un autre des éléments qui va être regardé et qui va être scruté par les tribunaux, c'est évidemment la réponse à l'incident de cybersécurité. Donc, on va voir si l'entreprise a répondu promptement, si les individus ont été notifiés rapidement. Et ça, il y a un corpus de jurisprudence, en fait, sur le délai qui est raisonnable ou pas, selon la grandeur, la grosseur du breach, le nombre d'individus à notifier, l'information qui est disponible au moment de faire la notification. Donc ça va être discuté à la loupe aussi par les tribunaux pour déterminer si oui ou non l'entreprise est fautive. On pourrait voir un cas de figure où, par exemple, l'entreprise arrive à déterminer que les données compromises étaient sensibles et qu'il y avait un real risk of significant harm. Et a décidé de ne pas notifier parce que, par exemple, c'était seulement 10 personnes, puis pour elle, c'était pas très gros, fait qu'on notifie pas, on balaie ça sous le tapis, un petit peu comme on a discuté tout à l'heure. Bien, ça, si un jour ça finit devant les tribunaux, c'est un des éléments qui va être analysé et la compagnie pourrait être responsable de justement pas avoir notifié ces gens-là alors qu'elle devait le faire. Et ensuite, dernièrement, ce que les tribunaux vont aussi regarder, c'est les recommandations ou les sanctions des Privacy Commissioners, fait que soit au Canada ou au Québec. Des fois, par exemple, on va notifier le commissaire au Canada et puis le commissaire canadien va nous revenir avec des questions ou des éléments supplémentaires qui devraient être faits pour être sûr que la notification soit faite en bonne et due forme. Donc, les tribunaux vont analyser les correspondances qui ont été échangées avec les Privacy Commissioners et les sanctions et ou décisions qui ont été émises par ceux-ci pour déterminer si le comportement de la compagnie était approprié dans les circonstances. Fait qu'essentiellement, ce qu'il faut retenir de ça, c'est que la Cour va regarder si l'incident pouvait être prévenu et si l'incident était évitable. Assumons pour un instant qu'une compagnie a commis une faute. Donc, on est au stade où la compagnie est fautive. Est-ce que ça veut dire automatiquement que les victimes doivent être indemnisées? Et c'est là où ça devient un petit peu plus tricky. Un n'égale pas l'autre non plus. Même si la compagnie a commis une faute, il faut quand même regarder si les victimes ont subi des dommages en lien avec l'incident de cybersécurité. Et là, ça, c'est un autre aspect qui va être évalué par les tribunaux. Puis la jurisprudence sur ce sujet-là des 10 dernières années est très intéressante puisqu'on se rend compte, plus la jurisprudence évolue, qu'il est quand même difficile pour une victime de prouver qu'elle a subi des dommages avec en lien avec un incident de cybersécurité. Ce que je veux dire par là, puis je vais vous donner les plus communs là, qu'on voit dans les dossiers. Première chose, on pense à un vol d'identité. Donc, quelqu'un qui s'est fait voler son identité en lien avec un incident de cybersécurité. Pour être en mesure de prouver le vol d'identité, elle va devoir, fournir la preuve que son identité a été volée puis qu'elle a été utilisée à mauvais escient. Mais elle va aussi devoir prouver que les données qui ont été compromises dans l'incident spécifique sont directement liées au vol d'identité. Je vous donne un exemple simple. Vos données ont été compromises dans un incident et on a pris votre nom, votre numéro de téléphone, puis votre adresse, par exemple. 2 ans plus tard, votre identité, vous faites voler votre identité, puis on se met à ouvrir des cartes de crédit pour vous en Alberta. Il y a des experts qui vont venir regarder les données puis qui vont venir dire tu ne peux pas appliquer pour une carte de crédit avec simplement le nom, l'adresse et le numéro de téléphone. Les compagnies de cartes de crédit vont demander plus que ça. Donc, on n'est pas capable de lier le data breach et le vol d'identité qui a eu lieu 2 ans plus tard. C'est peut-être dans le cadre d'un autre breach que ces données-là ont été compromises. Donc, on n'est pas capable de faire 1 + 1 = 2. Donc, cet aspect-là est difficile, puis c'est souvent des experts qui vont venir se prononcer sur ces questions-là. Un autre aspect auquel on peut penser en termes de dommages, c'est la fraude, donc les charges sur les cartes de crédit. Ça, les tribunaux sont venus dire que les cartes de crédit, maintenant, comme elles fonctionnent, sont tellement sophistiquées, c'est quand même difficile de se faire frauder sa carte de crédit puis de ne pas être remboursé par sa compagnie de crédit. Puis je suis sûre qu'il y en a plein dans la salle qui l'ont déjà vécu, là. Généralement, quand on a des charges qui ne sont pas les nôtres sur les cartes de crédit, on appelle la compagnie de carte de crédit et ils sont très ouverts à soit rembourser ces charges-là ou à nous dédommager. Donc, les tribunaux vont dire, à moins que vraiment vous ayez eu des charges sur vos cartes de crédit qui n'ont pas été remboursées puis que vous en avez souffert vraiment un dommage concret, ceci n'est pas un dommage que vous pouvez lier à l'incident de cybersécurité. Un autre élément qui va être regardé aussi, c'est le désagrément et le stress. Donc, les tribunaux vont regarder parce que lorsqu'on est notifié d'un incident de cybersécurité, il y a du stress qui vient avec ça, notamment de ce qu'on vient de discuter, là, les charges frauduleuses sur les cartes de crédit, la fraude d'identité, ce sont tous des risques qui existent. Les tribunaux vont demander que ce soit un risque qui sort de l'ordinaire pour qu'il soit compensable. Et ce que je veux dire par là, c'est que les tribunaux vont dire le simple fait de regarder vos credit statements, de monitorer vos comptes, de s'assurer que vous ne faites pas dérober votre identité, ça fait partie des inconvénients de la vie en société. Donc, ce ne sera pas un dommage compensable, à moins que vous soyez en mesure de prouver que vous subissez un stress qui sort de l'ordinaire, que vous avez consulté un psychologue parce qu'on vous a dérobé votre numéro de téléphone. Ce ne sera pas un dommage qui est compensable. Et finalement, les frais de surveillance de crédit, donc le credit monitoring, à l'époque, il y a de ça quelques années, c'était un chef de dommages qu'on incluait dans les actions collectives. Maintenant, je vous dirais que 80, puis dans 100% des dossiers qu'on fait, 95% de ce qui se fait sur le marché, le credit monitoring est offert gratuitement par la compagnie qui a subi l'incident. Donc, ce ne sera pas un dommage qui va pouvoir être réclamé devant une cour de justice. Les seules fois où on l'a vu que ça a été accepté, c'est que les gens le payaient directement de leur poche, là. Mais généralement, c'est offert par les compagnies, puis c'est ce qu'on suggère aux clients aussi quand il y a un incident de cybersécurité. Finalement, il y a également atteinte à la vie privée. Atteinte à la vie privée, en vertu des chartes, c'est un peu le même concept. Il va falloir montrer que ça sort de l'ordinaire et qu'il y a vraiment eu une atteinte à la vie privée. Donc, c'est pas seulement une réclamation de dommages qu'on peut mettre à large dans un recours collectif, là. Ça va vraiment prendre une preuve. Dommages punitifs aussi qu'on voit souvent, puis c'est souvent ça qui fait grimper les montants dans les actions collectives, c'est le montant de dommages punitifs qui est réclamé. Ça, il va falloir que la victime démontre en fait que la compagnie a commis une négligence grossière et c'est là que toute l'analyse des mesures de sécurité en place devient intéressante, ou s'est fait attaquer de mauvaise foi. Donc, aurait été de mauvaise foi dans la mise en place de ces mesures de sécurité de telle sorte qu'elle devait savoir qu'elle allait se faire attaquer, ce qui n'arrive pas en réalité, là. C'est très, très difficile. Finalement, en Ontario, puis j'en parle là, parce que ça, c'est arrivé à la fin de l'année 2022, il y avait un tort aussi qui était souvent invoqué, qui était intrusion upon seclusion, qui ressemblait à atteinte à la vie privée. Et en Ontario, en décembre 2022, la Cour d'appel est venue dire que ça, c'est pas une réclamation possible parce que c'est pas la compagnie qui porte atteinte à la vie privée de la personne, mais c'est le pirate informatique qui vient voler ces données-là. Donc, la compagnie ne peut pas être tenue responsable sous ce chef-là. Tout ça pour dire que les 10 dernières années nous ont démontré que les réclamations suivant des incidents de cybersécurité ne sont pas chose simple et que ça met un petit peu la table pour les prochaines années en termes d'action collective. Ceci dit, je ne vous dis pas qu'on va en voir moins, ne serait-ce que parce que au Québec, c'est le premier qui dépose une action collective qui a le droit de poursuivre dans cette action-là. Donc, souvent, qu'est-ce qui va arriver? C'est qu'il va y avoir un incident de cybersécurité, puis dans les jours qui suivent, le dépôt va se faire sans même que l'analyse complète du dossier ait été fait. Et souvent, les compagnies ont peu d'appétit pour défendre ce type d'action-là. C'est comme un incident qui est arrivé, puis on veut clore ça on met ça dans une bulle séparée, puis on veut clore ça rapidement. Donc, les compagnies vont avoir peu d'appétit pour défendre ce type d'action-là. Donc, il y a beaucoup, beaucoup de règlements qui interviennent dans les actions en lien avec la cybersécurité, ce qui fait qu'il y a des actions qui continuent d'être déposées puisqu'on voit que les compagnies ont un appétit pour le règlement. Ce qu'on peut voir avec ce qu'on voit dans les 10 dernières années, puis le fait que c'est pas facile de déposer une réclamation contre une compagnie, c'est que peut-être que les compagnies vont avoir plus d'appétit, à défendre, ces dossiers-là devant les tribunaux, donc passer le stade de l'autorisation puis aller dans ces dossiers-là parce que, on le voit là, c'est pas facile pour les individus de tenir la compagnie responsable, sur ces enjeux-là.
National ou c'est le représentant ou.
Généralement, ça va être fait sur le représentant. Ça va être fait sur le représentant, puis ça va nécessiter de ce qu'on voit dans les dossiers, là, ça va nécessiter une preuve par expertise. Justement pour faire la corrélation entre les données qui ont été compromises dans le cadre de l'incident de cybersécurité et spécifiquement qu'est-ce qui est allégué comme dommage par la victime. Ça va être vraiment sur le représentant que le test va se faire.
Avec preuve d'expert.
Exactement.
Um,
Non, c'est juste moi qui n'avais pas changé ma slide.
Next topic is board responsibility. So cyber risk is definitely a hot topic for board of directors, C-suites, officers of small and bigger organization, and for good reason. So the board of directors under Canadian law do have a responsibility to kind of oversee cybersecurity risk as part of their duty of loyalty, but most certainly about their duty of care. So they need to exercise the care, diligence, and skill that a reasonable, prudent person will exercise in comparable circumstances, which means that they need to consider all material information reasonably available, be informed of the implication of the cybersecurity risk, and do an oversight duty. So identified effective oversight of the management. Obviously, they don't need to be in the operation of management of cybersecurity risk, but they need to have a reporting to the board and oversight of that implementation within the organization. And they need to be particularly aware of any potential overlap between their legal compliance and their business risks. So they need to be aware of what they need to do legally speaking and where there's additional risk for the organization depending on the type of industry and the operation that's been conducted by the company. So moving to the next slide. So in terms of what we see in Canada, similar to what Marjorie mentioned in terms of class actions, that's why we mentioned director liability in Canada. It's a growing exposure in the sense that they are, they're being looked at, but there's no cases yet on DNO responsibility on their fiduciary duties for lack of oversight of cybersecurity in Canada. And a couple of reasons for that. One is that most of these actions will need to be taken by a derivative action, an action oblique, in Canada. And in Canada, as most of you probably know, you need to get an approval from the court in order to engage into such procedures. So therefore, it's a bit complicated in Canada, and there's no history of using that as a mean to go and seek recourses against the board of directors. And we'll talk about the U.S. in a second because the U.S. is a different perspective around that. So not surprisingly, given our non-litigious environment and the complexity of derivative action, there's authorization from the court, but there's not much in terms of case study that we can refer to in Canada. One important thing to say when we discuss with board of directors about cybersecurity is the same thing then any other oversight by the board. So they need to bring action, do certain action in order to benefit from the business judgment rule in Canada, which means that they need to be active and engage into this oversight responsibility. And we'll discuss that in a second, what it means by inspiring ourselves to what we see in the other side of the border. So what we've seen in terms of trend for board responsibility in the United States. So um, in the last decade or so, plaintiffs have been increasingly pursue the Kermark claims in the United States against the rector. We've seen at the beginning, 10 years ago, the Wyndon, the Target, the Home Depot, they each suffered data breach between 2008 and 2014, and there was a lot of derivative action being taken at the time. So each of them, and I think Marjorie mentioned, so they discovered the claims, and then there was a shoulders derivative action seeking to hold the board of director responsible for the failure again to monitor the company's cybersecurity program. Most of these claims have been unsuccessful in the United States still to date, and we'll touch upon the latest one in 2022, but mainly for technical reasons. So because they don't meet the threshold, the really high threshold under the Kermark claim. So the courts in 1996, the decision in Kermark established a legal framework to hold board of directors responsible for breaching their duties of loyalty. So we applied the same threshold and the same test when it comes to cybersecurity. So we're still applying now, numerous years later, this Kermark test to determine whether the board of directors can be held liable for a lack of or failure to oversee cybersecurity risk. So for liability to attach under the Kermark theory, the board must have entirely failed to provide any reasonable oversight in a sustained and systematic fashion. Or the information reporting system on which the board relied must be deemed to be an utter failure. So basically, when we look at the Kermark threshold, it's basically bad faith from the board of directors or pure negligence not to have put in place the proper protocol to either get the information, or if they got the information from management, they kind of looked at it, but basically failed to oversee the reporting information that they received. So, although in the context of a cyber breach, what we've seen in the last 2 years is recent cases in the United States where they did apply the Caremark test in other industries, but which gives us kind of some indication as to where the plaintiffs could be successful in making a claims against board of directors. So, what we learned from these recent cases is that if there is a non-existence of either a board committee or a board discussion addressing the specific risks and threat in terms of cybersecurity, that could be used as a mean to bring some responsibility. That was identified as one of the conditions where they could engage liability for the board. But not only that, they also mentioned a lack of procedure for reporting from management to the board of director concerning kind of the compliance program of the company, having presentation to the board not only as to what goes well, so the IT department coming to the board saying how their systems are so protected, what they've done right, but also have the other side, so presenting what goes wrong, how many cyber breaches, so in your dashboard to the board of director, going beyond being overly positive and having a balanced set of information being provided to the board. And the last one is having discussion at the board level, because what we see sometimes is report being provided, either distributed ahead of the board meeting, but not necessarily having a full-blown discussion at the board meeting among the board of directors. So this was also identified as part of those cases as being a potential failure to kind of oversee a risk, organization risk. So it's worth noting as well that the threshold in Canada, although there's no cases in Canada, the threshold will be much lower to have or to engage potential liability of the board of directors, because we wouldn't require, full-blown negligence or bad faith. It would be a simple fault if there's a failure to kind of supervise cybersecurity risk of organization. So the recent case in the United States is the SolarWinds case. So it's the most recent shoulders derivative lawsuits that was filed against the board, again, for failure to oversee cybersecurity incident. It's another example, as I said, of the trends of dismissal at the very early stage. So in that case, they still use the Karamark theory, and the demand for authorization was dismissed because the plaintiffs could not prove that the director defended either violated positive law, so didn't violate any law. They didn't fail to maintain at least a minimum reporting system about corporate risk, and they did not ignore sufficient red flag of cyber threat to imply a conscious disregard of a known duty of scienter. So in the United States, basically they're saying if you do have red flag, you're not acting on it, that could be taken against the board of director. So moving on, so what are the trends in all of that? So similar trends to what Marjanie mentioned. So regardless of history of failed claims in the United States, U.S. plaintiffs are continuing to file D&O claims against board of director. So why are they doing that? I think similar to what Marjanie mentioned in Canada for class action, they're doing it because they're trying sometime, and I'll touch upon the securities action. So they're usually filing a derivative action against the board of director, and they're filing a securities claims also against the board of directors for failure to disclose a cyber breach. So most of the time, they're trying to gauge which of those claims will be successful. And sometimes, and what we see more and more is that although they may not be successful on the merit of the case, but they might be able to negotiate a settlement with the company. So there is still incentive for ambulance chaser in the United States to kind of try to get a buck out of that. It's worth noting, too, in the last couple of years, two famous kind of settlement by the party pre-trial. So we can think of Equifax, which settled for $150 million, as well as Yahoo, who settled for $80 million. So there's still appetite for some of the company for different reasons to settle before the merit of the case. So moving now to securities law disclosure obligation, and then kind of the recourse that we've seen either mostly in the United States. So the other aspect that could bring liability to board of directors and officer is a failure to disclose a cyber breach. So what do we have in Canada? So there could be a risk of potential liability for misrepresentation under the secondary market liability. So it's the same rules as I mentioned, I said unfortunately or fortunately, there's no cases yet on the subject in Canada. But we can inspire ourselves as well a little bit from what's happening in the US. So, in a nutshell, in Canada, when it comes to cybersecurity, the same kind of reporting regimes apply to a cyber incident. So, issuer needs to report to a press release a cyber incidents that amount to a material change to their organization, and do file a material change report to the extent there is a material change. So I'll get to that in a minute. And then if they have to disclose all material facts regarding their cyber incidents in their annual information form and management discussion and analysis, or any other type of or documentation they're filing. What we've seen in terms of guidance, so that's the rule under the Canadian Securities Regulation. So on top of that, you have a couple of guidance that have been issued over time by the Securities Commission. The latest one being the Staff Notice 51347, which was done further through a thorough review of the S&P Composite issuer by the Securities Commission, kind of looking at the disclosure in the last few years in terms of cybersecurity, and kind of reciting kind of the best practices in terms of disclosure. So what they're saying is that they would like to see more description of the material risk, the cyber risk regarding the organization. And I think in practice, what we see and what they note in their staff notice, and we're trying to move a little bit away from that, but it's a boilerplate cybersecurity risk that we see for most of the organizations. Say, I may be subject of cyber breach. We may have a little impact on this operation, or kind of boilerplate language. What the Securities Commission are saying is that we've seen your disclosure, we think it's too boilerplate, and we would like you to increase and tailor it to your industry, your own risk, your system, what or your own vulnerability. And the pushback we got from most of the issuer, and I think we've seen it even more in the US, is that we don't want to, the response from the issuer was always, but we don't want to give a roadmap to cyber criminals that kind of go into my system and to show all my vulnerability. And the response from the SEC on that is that, yeah, right, but there's a balance between giving a roadmap and adding tailored disclosure about what happened. So basically what we see is company now are increasing their disclosure if they suffer, for example, of cyber breach, depending or not if they disclose through press release first, and I think I'll get that in a second. They still need to update their risk factors because it's no longer a theoretical risk. It's something that happened to their organization. So they need to address that as part of their disclosure. So the tricky part about cyber breach, and we discussed that when we discussed about privacy. I think on top of that, we said that the regime is kind of all over the place depending on where you do have operation and employees. But it's even more true when you do deal with public companies, because on top of your privacy obligation to report, you do potentially have an obligation to disclose that to the public. But when do you have that obligation? And although the test is clear, material change, we've seen in other contexts, but when it comes to cybersecurity, it's a trickier one because it's difficult when and we've seen it in practice with clients, is that when you realize that you're the subject of a cyber breach, sometimes you only have a piece of the iceberg. So one email has been compromised, everything seems to be running smoothly, so you don't have really indication that there's a material change to your operation. But then a few days later, you realize, okay, my whole operation in this part of the States or Canada is completely blocked, or 3 days later, no one has access to their email or to the system because it was one intrusion and then it's a ransomware attack. Everything is down. So it's an evolution determination for issuer to make that determinations, but they need to do that, as you know, promptly. So they need to determine by the time they realize there's a cyber breach, am I in a zone where I can say that there's a material change to my operation, or maybe at that time there is none, but it's not like they have to sit on that determination. They need to continue looking at it as the investigation involved, as the information comes in. So it's an evolution task that the issuer needs to run regarding a cyber breach. Other points. So if you look at what we see in the US, so as I said, in Canada, we have a staff notice now that's dated to 2017, so still a bit old. I think we would think that given the proposed rules in the United States by the SEC, the Securities Commission are kind of looking, as they are for ESG, as to what's going to come out of the United States in order to kind of tailor a little bit more their staff notice to what we see in our neighbor. So what do we see in the proposed regulation in the US? So they propose a couple of interesting things, which are being really scrutinized, but also criticized by most of the people in the United States. The first one is that they need to disclose any material cyber incident within 4 days after the issuer determined that it has experienced a material cybersecurity incident. So as I said, in Canada, it's promptly based on your material change kind of obligation. in the United States now they're saying is that you have 4 days to disclose the information. So it comes back to the same point. So if you have an obligation in Europe to disclose something, or if you decide to disclose something to the privacy commissioner that is incomplete, that's something to do because it's kind of private through your report. But if you do the same in the United States publicly, the risk of doing that is that you won't have all the information. You will be lacking some material fact that people will identify later on. So that may bring additional kind of class action or litigation around that. So I think that'll be interesting to see how that evolve and if that find its way into the final regulation in the United States. The other thing they're saying is that the disclosure to the extent known to management when a series of previously undisclosed individual immaterial cybersecurity incident has become material in the aggregate. So they want you to say that the determination is as a whole. And that's what we say also for a material change. If you have isolated small event that all in of itself are not material enough to require disclosure, now they're asking you to say, well, look at all of them and tell me that this is non-material information that the investor needs to know. So again, it's not necessarily easy for issuer to make that determination, and they may require them to go a way back to include that as part of their disclosure. They already had that, but they're increasing the disclosure on risk management, so strategy, governance, policies, and procedure, because they feel that the issuers in the States and in Canada, we see the same thing, are not giving enough disclosure around what they do have in place in terms of infrastructure for cybersecurity. And what is the board oversight of cybersecurity risk and management? And I think it goes back to what I said about the cases for DNO responsibility. So if you disclose what you're doing within your organization and through your public disclosure, then you have to be mindful if that could be used for someone in litigation to say, is that enough or is that sufficient to meet the threshold? General. Yep. Yep. It's your regular disclosure. Correct. And the last one is the disclosure regarding board member cybersecurity expertise. And this is criticized also because they proposed something similar a couple of years ago. And the reason why they're proposing, they want to make sure that the people around the table at the board do have the expertise necessary to assess those risks. But around that is say, I think we will see a trend where people having the expertise, and it's mostly not what we see around the table of a typical board of directors of a public. Those will be there's a limited pool of individual having that expertise. So I think it would be difficult to hire kind of board of director having a niche in that. And it's similar to other points where we say there's might be one person having that expertise, but how do you bring knowledge around the table for the whole board to have a similar expertise?
Well, if you're going to be the only guy shot down in flames if anything happens.
Exactly. That's one of the concerns as well. Exactly. Yeah. So quickly, because I think we're running out of time, but I think really quickly, what we see is securities law disclosure obligation. So there's, as I said, kind of litigation in the United States based on misrepresentation in the public disclosure. So we're seeing more and more. So the trends around that is that, as I said, people are trying with all the angles they can find to get kind of DNO responsibility or management responsibility for lack of oversight and lack of disclosure regarding cybersecurity. And maybe as a closeout comments, the other trends we see, and we didn't put in presentation, is police enforcement as well. So we've seen more police enforcement within our case. So, and how does this translate to is police kind of following up on old cyber breaches and connecting some information with privacy commissioner that they're able to gather in order to take enforcement action against cyber criminal. And I'm not sure they have more effective in order to do that, but we're seeing more in some of our cases where they ask some of the company, do you want to press charges? Do you want to be involved in some action they're taking against some of the criminals? And we've seen a lot of newspaper and kind of news presentation of that over the last year as well. So that's a continuing trend, I think, for 2023.
Exactement. Puis ce qui est intéressant aussi là-dedans, puis ça, c'est arrivé là, l'année dernière, puis on risque d'en voir de plus en plus. L'année dernière, la GRC a arrêté un pirate dans le coin de Gatineau. Ils ont saisi 700 000 puis 21 millions de dollars en Bitcoin. Et ils ont réussi à retracer les cyberattaques que ce pirate-là avait fait sur certaines compagnies. Ils ont été en mesure de redonner de l'argent aux compagnies qui avaient souffert les incidents de cybersécurité, notamment parce qu'ils avaient souffert des coûts en lien avec ces incidents-là, là. Notamment les coûts de notification, les coûts de consultation, etc. Il y en a qui avaient payé des rançons aussi. Donc, ils ont été en mesure de leur redonner en Bitcoin. Fait que là, on sait qu'aujourd'hui, ça vaut peut-être un petit peu moins, là. Mais bon, il y a quand même de l'espoir à ce niveau-là.
In conclusion, I would just actually like to thank Sean, who is here and who helped us put all this together, and also publicize or at least advertise the fact that we've decided to have a privacy roundtable quarterly at Stikeman Elliott. So anybody who's interested in attending this, please sign up. The idea is that people who have to deal with privacy issues in Quebec because we have newly appointed DPOs could come troubleshoot, and we'll just it'll be very informal and a session to meet other people and to talk to us. So if you're interested, we invite you to sign up, and thank you very much.
Thank you.
Merci beaucoup tout le monde, c'est un plaisir.